Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. This is David Adler, and this is the Health Law Hotspot. Thank you so much for joining us today. I have one of my partners, David Hochman, with us, as well as a very special guest, David Adler from the Adler Law Group. I'd like to have them introduce themselves, and then we can start talking about our topic today, which is branding in 2021, specifically for dentists, physicians, and other healthcare providers. David?
Hi, I'm David Hochman. I'm the shareholder in charge of the Chicago office of Roetzel and Andrus. I'm a member of the Health Law Group with Ericka, who is the chair of the Health Law Group.
Hi, everybody. I'm David Adler. I'm a sole practitioner. I've been practicing about 23 years. My practice is focused primarily on intellectual property law, including advertising, marketing, branding, related promotions. Many of my clients are entrepreneurs in the healthcare industry, and a lot of work that I do pertains to helping them with their advertising and branding issues.
Great. Well, the reason we've asked David to join us today is because as we start off a brand new year, 2021, a lot of our clients start talking to us and each other about how they can do things differently this year. And a lot of that really comes down to rebranding or refreshing their brand, whether it's considering taking on a trade name, a new logo, and a lot of them really don't necessarily understand what that process is and what they should be thinking about. We have, David Hochman and I have a lot of clients with very similar names. A lot of them like to start it with suburban this or women's that or lakeshore that, and doesn't matter what state you're in, that seems to be the most popular type of name for physicians and dentists to choose. So there is a lot of confusion sometimes and a lot of similarity. And there can be issues that arise, and I want to talk about some of those. But also, even when you think you're choosing kind of a unique name, you also need to still make sure that you're really the first one who thought about it, and to understand, if you're not the first one, what you can and can't do. And if you didn't bother to check and somebody comes to you and says, hey, guess what? I thought of that first, what your options are. So Dave, maybe you could talk to us a little bit about what people should be thinking about if they're looking at their name or thinking of changing their name or their logo. What are some considerations?
Yeah, thanks. Well, I think you said a lot in your introduction there, and you introduced a lot of concepts that I think are really important. The first one that I'm going to talk about is the one that you identified, just about the similarity in names. So, you mentioned you have a lot of clients whose name begin with suburban or Midwest or Lakeshore, right? And what I find pretty consistent among doctors and dentists is that they want to use a name that kind of tells people a little bit about the business. Now, that's good in the sense that it helps people it helps to tell people about what it is that you're selling. But at the same time, if it's too descriptive, then it really isn't distinctive enough to distinguish you from any other business. Okay. And so that's kind of what the crux of branding is really all about. And that's choosing a name that's distinctive, that sets you apart from the competition, and is protectable. Right. So when clients come to me and they say, okay, I'm getting ready to start a new branding project, what are the issues I should be looking at? And just like Ericka said, one of the issues is, am I allowed to use the name I want to use? So I picked a name. How do I know if anybody else is using it? How do I know if that's available to me? Right. So you want to make sure that if you choose a name, that you have the right to use it. And that's, one of the things that I do is I help my clients search that out to see if other people using the same name or a similar name, to try and avoid those kinds of conflicts.
How widely should you search? I mean, you run it like here in Illinois, we would look on the Secretary of State database and say, oh, it's not taken. And to get a name, sometimes all you need to do is change group to associates or add an S, right? And you can get a name that otherwise is identical. Should you be doing more than that, which I'm guessing most people don't really do?
Yeah, I think most people don't do the amount of research that they need to do. And maybe, it kind of helps to talk a little bit about the differences between trademarks and, corporate trade names and some of those things. So a trademark, just a basic trademark, is any word, name, symbol, or device or slogan that identifies a particular business. So it can be an individual word, it can be a phrase, it can be a logo. These are all, source identifiers. And, in legal terms, they're called trademarks. In common usage, they're known as brands, right? The interesting things about trademarks is that you can have trademark rights just by using your name. So you can pick a name and you can start using it. And the law says that you have some limited rights in that name. There are different types of trademarks. So trademarks run across what's known as a continuum of protectability. On one end, you have sort of generic terms and phrases like coffee, tire, Midwest, right? So those are sort of more generic terms. At the end of the spectrum, you have distinctive words like Google, Yahoo, Xerox. So words that are kind of made up. In the middle, you have what are known as either descriptive or suggestive terms. And this is where most trademarks fall because, like I said earlier, business owners, physicians, dentists like to choose names that kind of tell their customers a little bit about them, whether it's Midwest Dental Associates, right? Or, Suburban Women's Health. I don't know if those are real names or not, but, they kind of give they give you an idea of what sort of services you can expect to receive, right? The problem is they're not, the more descriptive you get, the less protectable you are. So you have to look at words that are protectable. In terms of securing your protection, right? There's a couple different steps that you can take. Like I said, you can get rights in a trademark just by using your name. And so, for example, let's say I was to register my company, David Adler Inc. At the Secretary of State. Well, one of the things the Secretary of State does for businesses like corporations, LLCs, is as long as you're not registering the exact same name, okay, they will allow you to register a similar name, and they will allow companies to be an LLC or a corporation, even though they have the exact same name, because their job is not really to police trademarks. It's just, just like there's, John Smith in Indiana, there might be John Smith in Illinois. It's a legal name. It's not quite the same thing as a trademark. So that's why you have these issues with businesses that have highly similar names on the business, the business registration records of a Secretary of State. And you may have the same entity, or not even the same entity. You may have different entities with the same name in different states, and they're different legal entities. And of course, this is what creates a lot of confusion. In addition. Okay, so in addition to just sort of the basic rights that you get from using a trademark, there is state registration of trademarks and federal registration of trademarks. I don't want to get too far ahead of myself. We could talk about sort of the different processes of those things in the scope, but
So Dave, I have a question.
Yeah.
So if I have a generic name, ABC Medical Group. Okay, am I going to be able to get a trademark for that, or is it too generic?
It's highly unlikely, okay, because it is, ABC is pretty generic. Medical Group is pretty generic, right? So it would be difficult to show that even that combination of words is distinctive enough to merit legal protection.
What if I couple that with a logo or stylized writing? Does that help?
That does help, because like I said, the key to protection is how distinctive is your trademark? How how does it stand out in a way that consumers look at it and they say, okay, I know what business that is, because there's elements to that are unique or are distinctive. So if you were to have even, let's say a generic phrase, but maybe it was in a very stylized text, or it was presented in a logo or a graphic format, those additional visual elements might be enough to protect it. But that protection would be limited, okay, against sort of the generic use of those same terms, right? So let's say you had ABC Medical Group, and down the road, somebody opened XYZ Medical Group, right? So you would say, hey, your name's too similar to mine. We both have Medical Group in our names,
Right.
right? But unfortunately, as you pointed out, Medical Group is descriptive, if not generic, for the services that are being offered. So I can't really prevent anybody else from using the same generic words I'm using.
We've had situations where clients having similar names, we find out that they are sued by accident. We had one client who I think was sued 3 or 4 times because his corporation's name is very similar to another corporation's name. And we had situations unrelated to malpractice where an unincorporated practice had signed a contract for radio advertising and defaulted. And the radio vendor, the advertising company, sued our client under the contract. They ultimately got the case dismissed, but it cost them time and money and legal fees, which they could have avoided had they had a name that was less generic.
Right.
Yeah, that's important. I think, again, the key is always sort of balancing the ability of your name to sort of communicate something about your brand, but at the same time keeping it distinctive enough that it's protectable, and it is, and it's not likely to be confused with others in the marketplace. Something that I've seen recently in my practice, both in the case of physician and healthcare businesses, have been very similar types of confusion. On the one hand, so I have a client who is a healthcare provider here in the Chicago suburbs, and she received a letter from a lawyer in Florida saying, cease using your name. My client owns this name. We've been using it since such and such a date. You're causing confusion. And if you don't cease using our name, we're going to sue you. And you've got 30 days to respond, right? Or I think it was even less. It was like 10 days. If we don't hear back from you in 10 days, we're going to sue you for trademark infringement, right? And obviously, my client was very alarmed to receive this letter, right? She didn't think she'd done anything wrong. She'd been happily doing business under this name for, quite a few years now, without ever hearing about this outfit in Florida, certainly, or anybody else really complaining about her name. And what's interesting is this, again, is because both businesses were very similar, names. One was like, something med spa. The other was something med spa. So they, they weren't terribly distinctive. They had some words in common. But, my client came and she's like, listen, I've been using this name since such and such a date, all these years now. And I said, okay, well, that's really important to know, because one of the key things to know about trademark law is that first in time is first in right. So if you're the first person to use a trademark, 99.99% of the time, your rights are superior to anybody else's. And so in this particular case, we did some research. We checked out the outfit in Florida. We realized that the entity that was claiming to use this trademark had really only been formed a few years before, certainly several years after my client had started using her business. We looked at what we could find about the use on the internet. We looked at, and it's interesting too, because in this case, the Florida outfit claimed to have a federally registered trademark. And in fact, they did. They had a federally registered trademark. They sent us a copy of the certificate. And as part of my due diligence, I went in and I looked at the specimen were making. The claim in their registration showed that they had started using the mark after my client had started using her name. There was certainly some doubt as to whether they were actually using the phrase the way they claimed to be using it. So, the long and the short of it is, after we were able to do some research, we were able to determine my client was in a very strong position because she had used her name first, and her rights existed prior to this other business. So, it was one of these things where, that comes up because the names are always so similar.
So if you have a practice, then, if you've been using your name a long time, you can be hopeful that whoever comes to you will have started using a similar name afterwards. It's never too late, though, to try. And I'm guessing a federal trademark means a lot more than a state one, correct?
Right, right. I lost that train as when I was talking about the example. But so I was talking about how you have trademark use or trademark rights at common law. You have state trademark rights, and then you also have federal trademark rights. All of these are overlapping, and no one is exclusive of the others, which is, it's good because the more protection you have, the better you are. Federal trademark protection grants the trademark owner a lot of rights and a lot of legal presumptions, and actually a lot of legal enforcement tools that wouldn't otherwise exist. So when you have a federally registered trademark, you have given the entire United States constructive notice of your rights to use this trademark. So if it's a business name or something like that, presumably you, the registrant, are the only one who's allowed to use this. And so having that gives you good standing, broad rights and certain legal presumptions.
And I guess so for our practices that have been practicing a long time, I mean, 20, 30 years, some of our practices are very old, they have pretty generic names. I'm guessing they're not super concerned, but a lot of our younger practices, where they are looking to brand, many of them are crossing state lines, looking at national models. We see a lot more national models, whether it's the med spa business and even many like vein or dermatology, gastro. A lot of them have much bigger ideas these days, maybe than maybe your small dental or medical practice down the road. And if they really are embarking on choosing a logo or choosing a name or a trade name that's different maybe than their corporate name, and they want to build a reputation and build a name around it, it seems that now's the time to spend the money, spend the time, spend the effort to choose something and protect it, make sure it's available, file that trademark now so that you don't have to worry about getting that letter one day and you're in the wrong. So if somebody comes to you and you say, hey, sorry, you started using this 5 years ago, these guys had a trademark 10 years ago, you never checked the database, you didn't know, and yeah, maybe people know your name and they know your logo and you spent a lot of money branding on your own social media, but guess what? If they sue you, you're gonna lose, right? So then you have a choice. Do I fight it, and not really have a good position to win? Do I spend the money to completely rebrand? I mean, those are business decisions, but if you're at the point right now in your business where you can plan ahead, talk to a lawyer now, spend the money to do the research and make sure you're not wasting all this time and effort, then I'm guessing that that's really the way to go.
Yeah, absolutely. If you are in the position of thinking about rebranding or launching a new business, you really need to do your due diligence before you come up with a name. And even if you have come up with a name, you need to check and see if it's available for your particular use, right? So this involves, a couple of different types of searches. There's no great tool for doing what's known as a common law search, but usually the way I work is I'll start with a federal trademark search, because as I said, when you have a federal registration, those are sort of like the most rights you can have. And the U.S. Patent and Trademark Office maintains a searchable database of all the registered trademarks. One of the things to keep in mind is that a trademark is registered in connection with specific goods or services, right? So you might have multiple trademarks that are the same or similar, but if they're for different goods and services, then they can coexist in the marketplace. In your case, you want to make sure that you look to see if anybody is using your name or your phrase or even your logo for the same types of goods and services that you intend. That's what's known as a knockout search. There's a little bit of an art to that search. There's services out there that you can hire to do this for you. But really what this does is it kind of gives you the lay of the land. It tells you if there's anybody out there who's using either the same trademark that you want to use, or if they're using a similar trademark for similar goods and services that might cause confusion. In either case, you want to avoid those situations. You want to make sure that there isn't anybody out there who's using the same name, or if it's a similar name, you want to make sure that your goods and services are so different from what they're trying to do that nobody would confuse you. And that's the point of a knockout search. And what's interesting is over on that, and we've often been surprised with the kind of things that we found. But at the same time, it's it's a good exercise because maybe the trademark you've chosen isn't available in its sort of initial version, and maybe there's something that we can do with your trademark to modify it. Maybe we add a word, maybe we change a word, maybe we change the spelling of a word, maybe we change the way it's presented. So once we kind of know what the lay of the land is, we can find a trademark that is going to reduce that risk that somebody else is going to have a problem with it in the future.
What about if you're like in Illinois and you have a really you have a great name, but you go into Indiana, and in Indiana somebody's filed kind of a state mark there. Could you be forced to use a different name in different states because of that?
So it really depends. The primary inquiry is what's known as consumer confusion. And consumer confusion is a fairly complex test. What I can tell you is, to some extent, certainly for things like medical practices, dental practices, where your customers are generally pretty geographically concentrated, your rights are really going to only extend to those areas where you do business. So in the case where you have a business in Indiana, and maybe you have another similar sounding business in Illinois, it's possible that, given the fact that they're in two different states, you may not get confusion. But let's say, people start crossing over, or maybe they're, one's in Gary and one's in Chicago. So geographically, they're actually very close to each other, if not in the exact same economic market. You might have confusion. Really, it boils down to sort of who used the name first, right? Who has priority of use based on, how long they've been using it. Having things like a state trademark certainly protects you within the state in which you operate. So, again, that goes to this idea of consumer confusion and protectability and, notice about people using a trademark. It happens, surprisingly often. And there's a long line of cases going back to, the early days of catalog advertising, when you had businesses in different parts of America mailing out catalogs, and using the same name. Today, what we see, which is, I think, something that we haven't mentioned yet, but I think is really something that physicians and dentists need to think about, is the fact that everybody's on the internet, right? Everybody's on social media. Everybody's on platforms like LinkedIn, Instagram. Consumers are routinely using internet search engines, mobile phones to find local businesses. We're becoming even more and more comfortable with the idea that we're going to go online to find something, find a service that we need. And for physicians and dentists, that means that, that real estate on the computer, on the phone, is hyper competitive. And it's, you need to make sure that you stand out on that you have a good solid brand name that you can promote, and it's not going to be confused, and that your customers and your patients can find you. So I think, not only with just the general competitiveness of the business, I think the shift that we're seeing, and we've been seeing for the last 5-10 years, is putting, I think, no more value, but greater risk on businesses around what they're doing to advertise and market,
and whether their name is safe. Right?
Yeah, exactly.
If you're in another state, you're more likely now to find somebody using a similar name or logo who you may not have come across otherwise, right?
Exactly.
So David, let's say I've registered my name. I have a trademark registration for my name. What should I be doing? How frequently should I be making a review to find out if somebody's out there infringing my mark?
Yeah, that's
my mark.
Yeah, that's a great question. So one of the things about having a trademark is it falls on you to police your trademark. And that means making sure that other people aren't using your name or using a similar name or using your logo in a way that competes unfairly with you. And so there's a couple of different things that you can do. What I do is I set Google alerts. So you can use Google free alerts to notify you if your trademark is being used on the internet. It's not perfect. It's not foolproof. It certainly wasn't designed for trademark monitoring, but it's kind of a very simple, inexpensive way to do trademark monitoring. Some of my clients actually hire me directly to go into the federal trademark database on a periodically, once every 2 to 3 months, just to see if any new applications have been filed that might be similar to a mark that we're using. The nice thing about that is the federal trademark application process gives people the opportunity to object to somebody else's registration. So if I have a registration, then I want to make sure that I know if anybody's filing an application that I think, might impact my name, or it might, maybe diminish it. It may not need to be exactly the same, but it might be similar. So I have a right to oppose that. Trademark monitoring is a little bit more involved. There are third-party services out there that you can hire, but at a minimum, you should be checking pretty regularly. Even if you just do something like a Google search your own name, search Facebook for your own name, right? Search Instagram for your own name and see what comes back. And you'd be surprised. You might find somebody out there who's created an account that's got the same name, or maybe there's a business showing up in a Google business listing that has a similar name. So, it's definitely something that you do need to monitor periodically.
I just have one more question, and then I think we're going to wrap up here. But what if you have a name, but you're using kind of a website that's maybe catchier, because social media has come a little bit later for some groups than their actual formation? Do you have any additional protections in like a website name, like www.somethingclever.com, when that's not really the operating name of your business? Do you have any greater or less rights? Or does it depend on how you're using that website? I don't know if that makes a difference at all.
Yeah, you raise an interesting issue. So there has been a long-standing discussion about the relationship between domain names and trademarks, and many people may have heard the recent Booking.com decision to just come down because it was a Supreme Court decision. It's pretty rare the Supreme Court actually deals with trademark matters. But the way the Trademark Office looks at domain names is that they are addresses on the internet, just the same way as your house might be 123 Main Street. Domainname.com is your address on the internet. So in and of itself, it's not necessarily a trademark. However, it could become a trademark. It really depends on consumer perception of it. So if you have a catchy name as your domain name and you use that name in your business and people associate that name with your business, it can become a trademark. It can get some protectability around that name. And it's even eligible for registration with the PTO as a federal trademark. But again, you have to show that it's more than just an internet address. You have to show that people associate that word or phrase with your business. And I've worked with a number of businesses over the years, many businesses who've protected their business name as a .com, or have gone the other way. They've started out with a domain name and sort of backed into a trademark registration from there.
Oh, great.
I had one other question. One of the questions you had raised earlier, Ericka, when we were talking, is what have you found that's unique for healthcare providers as opposed to other businesses when it comes to branding?
So I think, one of the things is what Ericka hit on very early in the discussion is the fact that a lot of healthcare providers, a lot of dentists use very geographic, descriptive terms in naming their business, right? And so the trick is kind of breaking out of that trap and coming up with names that are more distinctive. The thing is, you really have to go through a branding exercise. You have to think about what kind of words or names do I want to, commit to, invest in, to really identify my business and make it stand out. And, it's something I think that takes probably a little bit more thought and time than, a lot of entrepreneurs really think about. A lot of times, something pops into their head or they get an idea and they want to jump on it right away. They register the domain name, they set up the business, they launch the website, they create their Facebook group, but they haven't actually taken the time to think about how strong is this name? How protectable is this name?
Right. It's interesting because most practices, there are some dental practices use words like bright or smile or pearly, those kind of words and logos that go with it. So we're seeing a little bit more of that, but I would say, David, and I think you probably agree that most of the older practices are still very much tied to the street they're on or the little town they're in or whatever. And just because that's how people know them. But the similarity of names, I don't really know that many physician practice like a, women's, OB-GYN health. I mean, that's pretty generic, and you're going to find one in almost any town. So how do you take that? I mean, maybe they got to do it through their logo then, or their color choices or something. It's not that easy because people want to, when it comes to healthcare, at least I think, in the name of the, the place they're going, want to know what it is, where it is, what it does, So it's interesting though, but I said this before, and this is a good way to wrap up, is that the business of healthcare has really changed, and it continues to change. We have a lot of young, very entrepreneurial physicians and dentists. A lot of them are interested in multi-state practices. They're interested in, more of a global, so to speak, presence, where they're not just thinking about their small town practice. And I think, not that there's anything wrong with a small town practice, but these issues about how you're using social media and your name and your trademark, the bigger you become, the more important it becomes to have that name and not to have to change it or change your branding at a later date because it's more expensive. And so that's really one of the things that we wanted to share with our clients, as you start 2021, hopefully it'll be a great year for everyone. But if you're thinking about your business, starting a new business, rebranding your business, then, one of the recommendations that we make is to take the time and to do it right. Choose a name, choose a logo, and choose a brand that you can ultimately protect so that it's time and money well spent. So thank you so much, David, for joining us today. It's been a pleasure to have you. Do you have any last comments you want to make, or David Hochman, do you want to add anything further?
No, I second your comments. There's so many platforms, and there's so much advertising or so much exposure that you can have in social media today compared to what 5-10 years ago, that if you want to keep up in a very competitive environment, you've got to take advantage of that and put yourself in the best position you can.
Definitely.
Yeah, and the one thing I want to add too is whether you see yourself, your business really as a local business, or you have global aspirations. In either case, you need to think about protecting your brand on at least a national scale, because that's where your consumers are with the use of mobile, the use of social, the increasing use of internet and e-commerce. Whether you like it or not, you will be competing with other businesses who have similar names, even if you're not, intending to be in their area. It's just a fact of life on the internet. So you need to be thinking about what else you can do. And one of the things that I think I didn't really go into is just, what you can do to protect your name in terms of getting state registration or getting federal registration. And maybe your goal isn't to go out there and shut down other businesses. Maybe your goal is just to make sure you shore up your own name. And so that if somebody does come knocking on the door, you can say, yep, I hear what you're saying, but, I've protected my name. And so, I should be good to go.
Great. Well, thank you so much for those final words. And again, I'd like to thank everybody for joining us. This is Ericka Adler, and this is the Health Law Hotspot.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.